now being taped again. So, we haven't had a question about CPA 3, so why don't we start off with that question, then we'll get back in, into the work product doctrine. So, I don't know, V, Kevin, what's the question?
Go ahead.
You want to go? Okay.
Yeah.
The doubt we had was we get that part of it would be protected, but why wouldn't the other part be? Or how did that go?
If you recall the fact pattern, CPA 3 in our problem, at least it looked like was doing possibly some information that, let me just get back into problem 4.3. What page is that on if you guys read? 186. Let's just read it for ourselves. 12 CPA 3, the client's approval for advice about tax consequences of the plan which CPA 3 provides in the writing. And what we said is, or Kevin, you seem to acknowledge that if it pertains to legal advice, Code Section 7525 should protect CPA 3. I thought your concern was what wasn't privileged in that, and the part that's not privileged is anything that deals with tax return preparation.
Okay.
We know is not privileged information.
Okay. You understood?
Yeah.
Okay, now we're good.
Okay.
You're good, I'm good.
Yeah.
Thank you.
All right. So, the authors in our book first introduce us to the work product doctrine. Again, this is not one of those that you can go home today and just look at like a 2-sentence rule and say, I know the rule. It really, if you have a chance, or when you get a chance, I should frame it that way, you gotta look through and struggle and wrestle with these cases, because by looking and reviewing these cases, you'll have a much better handle on some of the issues courts and taxpayers and the IRS have to struggle with. All right, so I wish I could tell you it's straightforward, but you can see the court itself had quite the issue with this case. And then we went to page 204, text rod. Okay, now this opinion itself should give you an idea of how challenging it is, and I'll explain in a moment. Here, the question is, are tax accrual work papers privileged or not privileged under the text rod decision? Tax accrual work papers. Show of hands, who says they're privileged?
Depends on how they're used.
Right, or not privileged? So no one wants to raise a hand.
I feel like I remember you talking about this last class. I'm vaguely down remembering exactly what you mean.
Well, let me just give you, again, I will be, how do I say, not secretive in the least. I will tell you that in this case, the IRS prevails. The IRS prevails, and what you can extrapolate, right? If I tell you the IRS prevails, what does that make clear?
That it isn't privileged.
That the privilege does not apply, okay? All right, but this is not a case where, this was not one of those cases where the judge or the court issued a, how do we say, a 3-paragraph decision. To the contrary, the court had to struggle with this. So some of the things I highlighted, so we all know, second paragraph on the opinion, page 204, as a publicly traded corporation, Textron is required by federal securities law to have public financial statements certified by an independent auditor. So has to prepare this paperwork whether or not there's litigation on the horizon or not. Has to prepare the independent auditor these tax accrual worksheets. And it's pointed out that the IRS prevailed in a case called Arthur Anderson, that the IRS was able to get access. The Supreme Court gave the IRS access, but even though the IRS won about regarding its free access to tax accrual work papers, the IRS essentially declared that it would only look at tax accrual work papers in what it perceived to be egregious situations, where taxpayers immerse themselves in tax shelters, okay? So the IRS prevails in the Supreme Court case, Arthur Anderson, but the IRS said it's not going to universally ask taxpayers for their work papers. They're only going to do it in a very narrow context in which taxpayers may have engaged in tax shelters. And in this case, Textron, this is spelled out on page 205, apparently invested in 9 silos. Silos are an acronym for a special form of tax shelter. So the IRS wanted to get a hold of these tax accrual work papers because it believed. Go ahead, Peter.
In this case, is it similar that because the example you gave before with Bob, is it because of the minute that they gave the papers to Ernest & Young, it became privileged, they waived it?
Yeah, they waived the privilege, the attorney-client privilege for
Right.
sure.
Like
So
it to Ernest & Young,
they gave it to Ernst & Young, the attorney-client privilege is gone. So the question is, can they preserve the privilege in the work product document? And I have written the word weird on the margins on page 206, the third paragraph down. The third paragraph down, 3 or 4 lines down in the third paragraph, 4 lines down, it says, in some instances, the spreadsheet entries estimated the probability of IRS success at 100%. Well, to me, if they're estimating that the chances of IRS success at 100%, help me out here, guys. I mean, to me, that suggests that you have a frivolous tax position. You're taking it if you're saying that you have no chance of success. So that's weird, to me at least. All right, so and the paragraph that immediately follows, I have highlighted, which I don't normally do, all in red. It says, neither side disputed the immediate purpose of the work papers were to establish and support the tax reserve figures, the audited financial statements. Textron's evidence was to the effect that the litigation over specific items was always a possibility. The IRS did not deny that in certain cases litigation would result, although it said it was often unlikely. Whether Textron's evidence is materially different than that of the IRS remains to be considered. So we know what the purpose of these documents were, and just to affirm Peter's point, in the paragraph that follows, it makes clear that there was no attorney-client privilege here because the documents that were turned over to Ernst & Young, and that constituted a waiver. So, Peter, to your point, there's an affirmation. That paragraph specifically talks about the attorney-client privilege being waived. In the district court, who prevails? The taxpayer prevails. The taxpayer prevails. District court's decision that the work papers were protected work product involved both the descriptive of factual premises and legal interpretation of applicable degree. So the district court, again, this is a hard issue. On page 207, right after the indented language, says the court concluded the work papers were therefore prepared because of the prospect of litigation. So at the lower court level, they thought these work papers were created in part because these were aggressive tax positions, and that yes, they had to be prepared because they had to be turned over to the third-party auditor, but also it had a dual purpose that it would also be prepared because of the prospect of litigation. What's interesting, I don't know if you picked up on this, is the paragraph that immediately follows says, on appeal, a divided panel upheld the district court's opinion. So this case was appealed to the appeals court and was upheld, meaning the taxpayer prevailed. But, this is very unusual, but sometimes it does happen. The en banc court, if I pronounce that right, then granted the government's petition for rehearing en banc and vacated the panel decision and obtained additional briefs from the parties and interested amici. We now conclude, so here's the appeals court reversing itself. Okay, so in other words, the district court, the taxpayer wins. The appeals court, taxpayer wins, but then usually there's panels. Like the Second Circuit and Third Circuit is comprised of like 15 judges, and usually there are 3-person panels who sit on each of these cases. The 3-person panel voted 2-1 in favor of the taxpayer, and the court on its own volition said, we'll have all 15 judges hear the case together. Okay, and sometimes these circuit courts will do that. They consider it important enough. And with all the judges sitting together, they reach this conclusion, okay? Now that doesn't mean there was a unanimous decision, just means that the majority of judges on the appeals court reached this conclusion. So again, if you're saying, gee, I'm having a hard time with this, you can see this is not easy stuff, or else it would not be, going to the district court, to the appeals court, and the appeals court reversing itself. And if you had the opportunity, there's a lengthy and very interesting dissent. It's not, sometimes you don't get a meaningful dissent. The fact that there's a meaningful dissent means, hey, there's some really strong opinions out there about how this should have come out. So here, when it goes to the full court, the IRS prevails, and that the work product privilege does not apply. And again, guys, I could spend all morning, but we don't have all morning. They talk about why was this document prepared, and it draws the conclusion on page 208, 209, you can read that, but on page 210, it draws the conclusion that these tax accrual work papers were not truly prepared for litigation. That when a lawyer is going to court, lawyers typically who go to court don't say, hey, can we get an accountant to prepare a tax accrual work paper, right? That's not part of their repertoire, usually when you have a controversy. So, at least in the opinion of the circuit court, this kind of documentation was not prepared in anticipation of the court. If it's not in prepared anticipation of court, it is not granted the work product doctrine protections or privilege. So, I can talk all day about this, but it's summed up in one sentence, but just reading one sentence doesn't do the whole opinion justice. If you look on page 213, the second full paragraph on page 213, to sum up, the work product privilege is aimed at protecting work done for litigation, not for preparing financial statements. So there's the rule in a nutshell, but I can't tell you it's as easy as that. And then if you start reading the dissent is vociferously disagreeing with the majority opinion, and points out in the pages that follow several what it perceives to be flaws in the majority opinion's reading. So when you get a chance, if you haven't done so already, you should read this. What's clear to me, at least, is someday the Supreme Court really should take up this issue, because there is a strong difference in opinion, and once the Supreme Court renders its opinion, there could be less controversy. Any other thoughts on this? Anyone have an opinion on this? Okay. In the last case, the authors point out, if you look on page 225, the last paragraph, in US v. Deloitte, the government conceded on appeal that certain tax accrual work papers referred to as the Dow documents were work product, but argued that Dow had waived the work product protection by disclosing them to Deloitte, its audit firm. Portion of the opinion rejecting this argument appears below. So, just how, as you could potentially waive the attorney-client privilege, right? Everyone agree? You could potentially waive the attorney-client privilege. The question, beginning on page 226, is can a taxpayer waive the work product doctrine, okay? Can the client waive the work product doctrine? And the US says yes, taxpayer waived it. Who wins in this case to give away the cards? Does the taxpayer win, does the government win? Here the taxpayer prevails. And US v. Deloitte, on page 226, said there was not, emphasis on the word not, there was no waiver of the of the work product doctrine. There was no waiver. In the second full paragraph on page 226, there's a statement, 8 or 9 lines down. Nevertheless, disclosing a work product to a third party can waive protection if such disclosure, under the circumstances, is inconsistent with the maintenance of secrecy from disclosing parties, from the disclosing party's adversary. So you can potentially waive the work product doctrine. The paragraph that follows says, applying the standard, the government contends that Dow was waived work product protection for the documents because Deloitte is, quote unquote, a potential adversary, and 2, a conduit to other adversaries. And that to me seems the government as a very weird argument it's making. It's saying that the taxpayer waived the work product doctrine because it has audited financial statements that Deloitte could become an adversary, and when it gives it to Deloitte, it's waiving his privilege? To me, that seems...
Well, isn't Deloitte in a way an adversary if they're doing internal audits?
Well, well, maybe that's why the government took this position.
Yeah.
Look at the first paragraph on page 226 after number 1. Government tends that Deloitte is a potential adversary of Dow because disputes sometimes arise between independent auditors and their clients, and because independent auditors have the power to issue opinions that adversely affect their clients. So having said that, that's just an affirmation of what you're saying, that they potentially could be adversarial. Doesn't happen too often, but I mean, that's the role of a third-party auditor. But
that's what I was saying last time, that I got the cases confused. That, I didn't think it would, because when they're hired as independent auditors, they have to be able to perform the duty. They can't be, worried about whether the adversaries can affect the opinion.
But hold on. Look at the first paragraph on page 227, 3 or 4 lines down. In preparing Dow documents, Dow anticipated, we conclude that the answer must be no. In preparing the Dow documents, Dow anticipated a dispute with the IRS, not a dispute with Deloitte. In other words, sure, it could arise, but these documents, they're not, most taxpayers are not. B, is it a fair statement? Anticipating disputes, right, Peter, with their third-party auditor, right? You wouldn't call them an adversarial relationship. I mean, they're gonna try to work out their differences and maintain their relationship. I wouldn't say that when you make disclosure to your third-party auditor of the work product doctrine, I mean, to me, any large company, which, you know, most of them are gonna get certified financial statements, then wouldn't that be the death knell to the work product doctrine for large companies? I don't think courts wanna go there, particularly since Congress enacted a rule, right? Congress took the Hickman decision and memorialized it in Rule 26B3. I don't know, you know, just as we saw Judge Kavanaugh in the Loving decision said, Treasury Department, by writing these regulations, now you're impacting 600,000 tax return preparers that Congress never explicitly authorized. Don't you think you're overstepping your bounds? Similarly, wouldn't the court be implicitly overstepping its bounds if all of a sudden it said, Congress, we're gonna make sure that the work product doctrine doesn't apply. And I think Congress would have expected it to apply kind of universally. Certainly this would have been an incredible leap on the part of the court, had the court upheld the IRS's position. So I don't think it's truly an adversarial relationship. And if you keep reading the opinion, Deloitte does not serve as a conduit to other adversaries. So I think the government was short-sighted in bringing this opinion. One or two things I will just call to your attention. On page 228, the third paragraph down, we conclude that Dow had a reasonable expectation of confidentiality because Deloitte, as an independent auditor, had an obligation to refrain from disclosing confidential client information. And talks about Rule 301, which we talked about in our class. It's in the back of our book. Talking about that, and then it just goes on that likewise, sort of that under the work product doctrine, this should be protected information. So bottom line, guys, your takeaway from this morning about the work product doctrine, it's a developing doctrine. It's been around for over 50 years. It's one of those doctrines that can protect you even if the attorney-client privilege has somehow been waived, okay? But there must be a nexus of some sort to potential litigation, okay? There must be some sort of nexus to potential litigation. If there is none, you can't argue that this document was done in anticipation of litigation. Doesn't have to be immediate, doesn't have to be that there's been a case filed, but whatever the document is, it's supposed to, again, have some connection with litigation. So if you guys want, let's go to problem 4-19. For tax accrual work papers that are prepared for reasons other than to comply with the SEC rules protected under the work product doctrine. For example, suppose a privately held company with no intention of going public voluntarily undertakes a similar analysis to support its financial statement, perhaps to strengthen its application to increase for an increased loan from its bank. Now, can I have a show of hands where you gotta raise your hand one way or the other? Don't. Who says that, in this case, tax accrual work papers would be protected, privileged, I should say? Who says not privileged? Show of hands. Privileged? Not privileged. If you said privileged, B, Kevin, John, did you say privileged too?
Yeah, I did.
John, why did you say privileged?
I just don't see how it's very different than the case we just looked at?
Just pretend it's an exam, you can't just say, it looks similar to a case we studied in class.
The, forget the
Well,
word.
just tell me what were the, instead of just saying which case, but what were the attributes that said? Kevin, you're gonna.
It has nothing to do with a tax shelter. They were only gonna use them.
Well, keep
if
in
it
mind,
was
hold on,
a
Kevin,
tax shelter.
you're making a good mistake today insofar as, remember, the work product doctrine has nothing to do with tax shelters. It's not like code section 7525.
Okay.
So, if you don't mind, I would mark that wrong, because
Okay.
you're mixing apples and oranges, right? Anyone have a strong opinion and say this is the right answer and why? Gus, you have a strong opinion?
No, I said it was a no.
It was not privileged?
I say no because it's used for financial statements.
And so what? So
And,
it's used for financial statements, Mike, keep going.
But it's a private company.
Go ahead, Trevor.
There's no tie to like anticipating litigation.
Yeah, there's no tie to anticipated
There's no-
litigation. Mike, to your point, it's prepared strictly for financial statement purposes, right?
Looks like they're gonna disclose it to a third party anyway.
So it is.
Okay, but having said that, it's not an adversarial third party. But putting that issue aside, there's nothing here that looks like it's being done in anticipation litigation. It's trying to beef itself up and get a bank loan, or suppose it was gonna be sold. They were looking for attracting more capital. I mean, we could paint all these things, and they get these tax accrual work papers. Hey, there's no anticipation litigation, no protection. Okay? And in general, Textron says, tax accrual work papers generally don't have protection. Right? And Kevin, again, I'm just gonna, just because it's useful, because a week from Wednesday on the exam, you wouldn't want us to talk about the work product doctrine and tax shelter necessarily,
Okay.
right? You could, but not to the point where,
Not in that context.
not in that context. 4-20. BP for public court has requested a memorandum from outside counsel explaining a very technical corporate tax issue that is relevant in structuring a contemplated transaction, and subsequently reporting that the transaction on public corp's tax return. Is the memorandum protected by the attorney-client privilege and/or the work product doctrine if BBT shares the memorandum with in-house attorney in public general's counsel's office, managers of the business units that will be involved in the transaction, outside counsel is doing corporate paperwork for the transaction, for public corp's regular outside tax accountants who routinely consult regarding ongoing tax issues, participate annually in the preparation of public corp's tax return. So BPT is getting a legal opinion, right? Because it's going to outside counsel about a transaction, okay? Let's just start before you share any of this with anyone, okay? Suppose you get a legal opinion. Is that protected by the attorney-client privilege? Is it protected in the work product doctrine, the memorandum? Okay?
Both.
You think it's protected for both?
Yes.
Anyone have a different opinion? Everyone thinks it's protected by both.
Just a turn on.
Okay, why just the attorney-client if you say that?
Because it's communication.
Yes.
Versus the work product, could be both.
Could be both, but that's what Ping said. Kevin? You're gonna say?
I just think that well, it all depends if the client gave the permission to divulge the information to
Hold on,
everybody in there.
before we even get to divulging, if the memorandum is simply prepared, forget about to whom it's given.
Okay.
Is it protected by the attorney-client privilege? Is it protected by the work product doctrine?
It's not in anticipation of litigation, it's just.
Yeah,
Possible
exactly.
potential.
All right, so let's start with the easy. Attorney-client privilege should apply, right?
Mhm.
Okay, there's communications, should. But the work product doctrine is harder. I'm not saying impossible, right? Depends on what circuit, right, Andrew, you're in. Because if this is not a controversial device, then we can't anticipate litigation, right? Everyone agree that if this tax planning device, just routine people, and you wanted a memorandum, it probably is not protected under the work product doctrine. Conversely, you get more protection, not less protection, more protection. The more controversial, I know this sounds counterintuitive, but think about this, Brian. The more controversial the tax planning, the more likely it would be protected, right, Dixie, from the work product doctrine, because it's more likely that it's going to result or erupt in litigation. So the more aggressive the technique, the more likely the work product doctrine would apply, because it's great. There's a greater chance you secure that memorandum in anticipation of litigation. More aggressive the planning, the more likely the attorney-client privilege would apply. The work product doctrine would apply. Thank you. Work product doctrine.
So can we also just assume that audit is litigation?
Say again?
Can we assume that an audit would lead to audit litigation?
Yeah, an audit,
Starts.
sure. I mean, if you're under audit and you have a memorandum, that to me clearly should be under the work product doctrine. Everyone understand Peter's question? If there's an audit commenced, you can anticipate it may not result in it, but if there's litigation, you would not want the IRS to get access to memorandum that you're being audited during the time you're being audited. Now, that wasn't even the issue, right? The issue was, are there waivers here, right? And you share the memorandum with in-house attorney and general counsel's office. Well, that's not going to constitute a waiver. Phoebe, you were going to say something?
No.
That's not going to constitute a waiver, right? Not going to constitute a waiver because there's every expectation that we're all on the same team. So that's not a waiver if you're sharing the information with the client. I would argue too that the managers of the business units involved in the transaction, that too is not a waiver because it's all part of, that's still the client. C, outside counsel is doing the corporate paperwork for the transaction. Again, I think this is functioning as a whole. You're not disclosing it to some unknown third party. Once you, in question D, you share that information with your outside tax accountants, that you may have waived the attorney-client privilege in that context, right? Because there it is going to a third party. But there, in question D, if the work product doctrine were to apply, even if you shared that information, in question D or part D, the work product doctrine privilege probably has not been waived, right? So the fact you waive the attorney-client privilege does not mean that you waive the work product doctrine. what happens in 4-21? What would be the result in Textron? Would the result in Textron be the same with respect to Fin 48 work papers for a year in which Fin 48 applies? Fin 48 has been replaced, right, guys? I'm drawing a blank. It 70, get the gap rule, but this essentially, Fin 48 dealt with uncertain tax positions, and where you have to disclose them on the financial statements. Do you get work product doctrine protection if you have to make disclosure with respect to gap disclosures? And the answer is probably not, right? Because when you have to make gap disclosures, you're not doing it in anticipation of litigation. You're doing it because you're trying to comply with gap, right? It's not being done in anticipation of litigation. So here, you probably cannot invoke the work product doctrine if you have paperwork pertaining to that has a different agenda. So for your notes, not privileged. Right, so let's talk about chapter 5, unless any questions about chapter 4. So, as we know, that lawyers are supposed to practice law, just like doctors are supposed to practice medicine, and accountants are supposed to practice accounting. We can go through what everyone's destiny in life is, but for the moment, we're going to stick with lawyers and just say, theoretically, the bar sanctions their ability to practice law. And why does it get the word profession? Because it's a self-policing group of individuals who are supposed to safeguard and make sure the public is well provided for, just like doctors are a profession, accountants are a profession, that they're supposed to make sure that people who participate in this profession are up to speed and do the right thing. And if you engage in medicine, what was the name of the movie? I'm drawing a blank. Who is the guy? DiCaprio. What was the name of the movie where what is it? Where he was doing like 20 different roles?
Inception?
No.
Catch Me If You Can.
Catch Me If You Can, right?
Oh,
Catch Me If You Can. He was a pilot. He was a doctor. I think he performed
Tom
surgery.
Hanks also. Yeah.
Yeah. And no medical training, right, Ping? Was he really a pilot too? Did he fly?
I read his book, and he said he never actually flew a plane. He was always like a side person. Not even a co-pilot, just like someone that sat in the cockpit.
That would be scary.
I thought he actually passed his medical exam, too.
He passed his medical exam?
But that was in the movie, I think.
He passed the bar.
Or the bar exam.
Yeah, he passed the bar exam.
But he really passed the bar.
was very smart.
And what happened, what was his punishment, do you guys remember?
He was punishment, he was used again by the FBI as a worker, right? He was hired by the FBI.
He was put in French prison for a while, and then he served some time in the U.S.
Okay. So, if he was part of our class, I could have him here give a little speech about what he shouldn't have done, which was practice law, okay? But hopefully you guys, after reading chapter 5, do we remember his name, his real name, or I don't?
Frank Avenue.
Frank, we could tell Frank, what he could and couldn't do. So, I don't know if you guys were ambitious, how many of you were ambitious, if any of you were ambitious, if you read at least the beginning of chapter 5. So, if not, I will continue and you guys can hear my monologue, that's okay. Anyone have a chance beginning on page 232 to read this Agron v. Shapiro case. I see a lot of white books from my vantage point, but maybe some used books with some markup. But did you get that far, Peter? Anyone get this far? What was that, Peter? Deloitte was the last. Anyone get this far, or you guys have to endure me? All right, endure me and indulge me. So let me talk to you, and when you get a chance to read, I told you, let me just, if you haven't done this already, we're gonna go a few more pages, and there's a few more problems, and we'll get through it. The good news is, after today, for Wednesday and for next Saturday, the reading, if you do the remaining pages, is much lighter, okay? There's a lot of pages for today because of those work product doctrine cases, okay? But the reading will be correspondingly lighter for our next class. In case, I'll say it now, I may say it again. For next class, you should finish reading chapter 5. And for our last class, will be the latest reading, will just be chapter 6, okay? And chapter 6 is all of like 20, 25 pages, so you'll see chapter 5 is not Herculean. But let's talk about some of the, I'll try to, chapter 5, at least the preliminary material is not that challenging. And we'll do a few problems, and by that time it will be 12:30. So let me just call to your attention, beginning on page 232. Now keep in mind, this decision's a half a century old, but see, it would scare many of you if you just look at this case, because here, the CPA, and if you guys don't mind role playing, this could be you, okay? This could be you. Plaintiff is a certified public accountant, and the plaintiff is doing something which I said you should never do, ever, ever, which is what? Well, you're not a lawyer. In this case, it's a CPA, so.
Sue your client?
Sue your client. Okay, here we have a CPA who's suing his client to get his fee. And you know why he's suing his client? Because he knows he did a great job. The CPA knows he got this great result for his client. Right? Essentially, the IRS came knocking for $6,000 and ended up collecting zero. So the client says, "Look, I saved you $6,000. I'll get 1/3 of it, or $2,000." And apparently, I'll say, agreed on that before the work even commenced. So it's not like, surprise, I'm going to charge you more than you anticipated. I think the client knew right from the outset he was going to owe 1/3 of whatever this accountant was going to be able to say. So I know, I'm hoping, even after being here 3 hours, this is getting your blood curdling for those who didn't read the case. Like, picture of yourself, you just worked several days of your life, you've got this great outcome, and you got the asshole client who's not paying, right? Everyone's blood curdling a little bit. What was it, Rita?
In our like small CPA firms, they are doing so much this type of work. They do work and then they will say, we will pay you later. Oh, we will pay you later. It's like the whole year and they didn't pay. When the next year tax return is coming, that time they will pay the previous fees. So
you need a new system.
Yes.
You do need a new
Yes.
system. That's too frustrating.
so much.
Yeah. Well, if it makes you feel any better, this doesn't happen too often, but I shouldn't, from a glass house, I shouldn't be throwing stones. I recently sent a client, I generally, except with tax collection work, I never ask for a retainer. And generally I get paid, but once in a while you get the client who I spent hours doing this plan for. And then she sends me a quick email saying, I've decided not to proceed, after sending her like the 3rd rendition of drafts. It wasn't, sometimes people are nice, I've decided not to proceed, can you please send me an invoice to date? I get a lot, I don't get a lot of that, but once in a while I do, and but this was just like, I decided not to proceed. So I figured, you know what, this was just so irksome. And I knew I had done everything just what she wanted. So I sometimes just would let it drop. But I just figured, let me just send an invoice showing instead of $3,000, I'll show 3,000 and say, in fairness to me, let's just make it $1,000 a month. And what response did I get?
No.
I got no response, not a no, just no response. Ouch. But you know what? I will probably never hear from that person again.
Go sell it to a collection agency and get some money for it.
You know what though, it's not worth it. My credo would be violated, which is you never sue a client, because.
That's not suing, you're selling.
Well, the other thing, and this is my own fault, I get retainer letters before people ultimately leave my office when they sign the documents. I generally don't ask before, which is my own, I should. So I would have no chance with a collection agent. The first thing.
This is the main point. Whenever we ask the client, right, your tax return is ready, you have to bring the check, sign the tax return and take it. So after I think I joined my company, after 2 years, I keep it this policy that whenever your tax return is ready, you have to bring the check and take your tax return. But some client, they are saying, oh, this is our friend, we don't have to do it right now, we have to do it later, and that's.
Some friend.
Yes, that's fine.
All right. Anyway, hopefully you guys see the dynamics here in this case. Accountant like yourself does great work. Client agrees to pay, gets the result client craved for, and then says, nope, not going to pay you. And the accountant sues to get funds, and what's the first thing the client says? No, you were engaged in the unauthorized practice of law, so I don't owe you a penny, because you were practicing law, you weren't practicing accounting, and therefore I don't owe you a penny. How does that, Dixie, sound good to you? No, you're supposed to be angry. Everyone in this room angry? Okay. Now, look, if this was pure tax return preparation, that's not the practice of law, but again, when you read this case, it dealt with a complicated issue of NOLs. So the accountant here wasn't just your generic accountant. This is a very good accountant like you guys, and had to look into and research the availability at the time. It still is Code Section 172, which deals with net operating losses. Had to research it and come up with the right answer on page 234. Talks about the fact the accountant spent 4 days immersed in research, and on page 234 elaborates got a great settlement entirely in the taxpayer's favor. I mean, this was a complete KO for the taxpayer. So taxpayer should have been celebrating and saying, boy, I should pay you a bonus, but instead says, I'm not going to pay you anything. Okay. So now the question is this person practicing law or practicing accounting? And the court admits that when you're doing this kind of work, it's blurred. There's some legal aspects, some accounting aspects, right, about NOL computations. I do want to point out to you who gets involved in this case and files amicus briefs. Well, the American Bar Association gets involved, right, because it has skin in this game. Why? It doesn't want accountants treading on its turf. And the CPA, AICPA gets involved. Why? Because it feels that this is legitimate work. So this case, even though it's between two small timers, have the big hitters here, right? Because the ABA and the CPA, that whole world, the California Society of CPA, knows that their world is going to be impacted by the outcome here. So the stakes are larger than they look. And the court beginning on page 236, talks about all the legal research the client had to do here, and talks about various cases that came before it, because courts always want to look at what do they do, you know, what they're doing is in line with what other courts have done before. And much to your surprise, who wins here?
Fine.
The client, meaning the CPA loses. The court says the CPA should not collect, that this was the unauthorized practice of law. That this was truly a legal issue. So really go through this case, guys. But remember, this case was over 50 years ago. And the world has certainly changed, and what people do in their professions have changed, in my opinion, but I think it's a shared opinion, it's not just my opinion. In the year 2019, I think the client here would have been laughed out of court. Of course, I would encourage everyone in this room and all my students that you could do this work. This is not just the domain of lawyers. So I think this is a false read on the unauthorized practice of law, right? That
I think just by looking at it, it kind of goes to everything we learned from Kavanagh's case, that all those statutes that they were fighting for now apply here, because they're all practicing in front of the attorney.
Oh, right, we have Circular 230, which specifically authorizes CPAs to, you know, never say, right.
That's now.
Right, but remember, Circular 230 and the whole statute have been around since the end of the Civil War, so it's and you know what's the most ridiculous part about this? Why is there a rule against the unauthorized practice of law, or the unauthorized practice of medicine, or the unauthorized practice of accounting? Why do the professions have those rules against people like Frank?
Barriers to competition.
Yeah.
Well, they don't, hopefully, let's not be cynical.
I mean, that's just basic economics.
No, but I mean, you're not gonna say that out loud. You're gonna say, we have these rules to protect the public. We don't want Solid to perform surgery, he has no training.
You need licensed haircutters, I mean.
Well, they're not considered a profession, but.
In New York they are, you need a license to cut hair.
All right.
I mean, we all know why this is done in reality.
Let's talk about the professions though. In theory, it's to protect the public, okay? And that's why lawyers don't want the unauthorized practice of law theoretically, because if you do, I mean, doctors, if you're not really trained to be a doctor, could misprescribe medicine, cut the wrong arm. You know, we could go through all the things that could go wrong.
They still do that.
They still do that, but there's less of a chance, right? Fingers crossed, less of a chance.
Like some countries, they don't mix it up the professional. Like they don't, the lawyer not is like CPA. They both have different professional.
Different roles.
Yes, like in our country, CPA is different.
Our country being India.
CPA is different and attorney is different. They don't mix it up together.
Okay, they don't.
No.
They're very defined.
Defined.
Okay, but obviously you see in the U.S. that is not the case.
That's
Right.
the problem. That's the problem.
But here, right, keep in mind the public policy objective sought to be achieved by stopping the unauthorized practice of X, fill in the blank. Well, here we have a CPA. Did the public need to be protected? No, he did it for big, excuse my language, a little punchy now. He did a great job, right? Everyone agree? Who needs protection here? So it's the antithesis of where the public needed to be protected. Like, if the taxpayer got a terrible result, taxpayer could perhaps bring him before the Bar Association and say, hey, this person was practicing law, they really were not qualified, and there's a problem here. So how the client, who I'm going to say is a bad person, do I really know Mr. Shapiro or Mrs. Shapiro? No, I have no clue. But, you know, I feel badly for the CPA, did his job and should have been paid accordingly, and did a good job, a great job. So how the court arrives at this conclusion, the authors have it here to put you on notice. You do have to be careful. I don't think you have to be as careful as you once were 50 years ago. There is a lot of blending that goes on, okay? And if you read at beginning on page 242, it's a nice summary of the world. It's a nice summary of the world, of what's going on. On page 242, the authors talk about the second full paragraph. The bottom line is that there's comparatively little litigation of the unauthorized practice of law in cases of the tax area, and talks about why that is the case. So in yesteryear, you would have to worry about it, not so much anymore. And it points out on page 243, first full paragraph, state authorities, on the other hand, often shy away from unauthorized practice of law cases. And even if they are, if the client complains about the fee, in the paragraph that follows says, despite the inherent confusion about the status of tax practice by non-lawyers or out-of-state lawyers, the consequence of engaging in UPL as unauthorized practice of law can be serious. The practitioner may not be able to collect a contractual fee, although some courts are willing to consider recovery on a quantum meruit basis. If V had her computer, she would look up the word quantum meruit, which many of you may or may not know just by looking at the words. It means payment based on the merit of the services performed. So even if you couldn't collect directly, you may be able to collect something in the way of a fee. Right, so let's go through.
I kind of see that that's true, because in New Jersey, there's a lot of Latino market from South Central America.
Go slow. There's a Latino
in the
market.
Latino community, there's a lot of South and Central Americans that come, and in their countries, a notary is known to be a lawyer.
Right.
So when they come here and they go wherever, they see notary public, they're going there with the impression that they are speaking to an attorney or getting legal advice. So then what happens is that the individual on the other end, because they want to capitalize, they don't disclose it. So I guess because they didn't say I wasn't or I was, it seems like there's no harm done, but
There could be real harm done.
I mean to the person, so the individual wouldn't know.
The
So
next
I've
one,
read
like
that,
magistrate.
I've read that they're trying to crack down on that, but I don't see, I still see them popping up everywhere. Like they'll go there for certain documents, wills, bill of sales without having a real business contract. They get away with it just because they're a notary. And they charge whatever they want, depends on what it is they're doing.
All right.
It's not practicing in front of the court, but you're providing certain documents.
No.
Or they'll get forms that are pro se and then fill them out.
I mean, look, you can go on LegalZoom.com, and then if you're a notary, what Peter's saying is you could play the game and say, look, I prepared these documents, and they're not really trained to fill in the blanks. Filling the blanks can be very dangerous if you don't know the consequences of what you're filling in and what you're putting in and what you're removing. Cutting and pasting is, I've seen very, very wealthy people, just like some people try to self-prescribe medicine of sorts. People will, doesn't matter how much they're worth, will create their own legal documents and create wills. Warren Burger, you might say, who is Warren Burger? Does anyone know who Warren Burger is? You have. He's the former Chief Justice of the Supreme Court. He died about 15 years ago. Had singularly one of the worst drafted wills ever created. It looked like a do-it-himself, and look.
Himself is the Chief Justice.
But
He's the
yeah,
chief.
he should be able to draft his own will.
You would think, but you know what? Like everyone has their own area of expertise. Like I'm a lawyer. I would never get involved with a bankruptcy. Like, in this day and age, if you're a doctor and you're a hand specialist, should you be operating on someone's foot? Probably not. And we exist in a very specialized world. So some people are delusional and think, oh, I am X and I can do it all, but generally there's just too much knowledge tied up with each element of what we do in this world. So, so he had a really, really bad, and I see that a lot, where people convince themselves, very wealthy people too, that they can do it themselves, and then when sadly they pass away, and their kids are left dealing with documents that are incomprehensible, then it becomes a real issue. And if I haven't said it already, I'll apologize about my repetition, but, you may have heard when people come into your office and they say, this is simple. We all know what the word simple means. That's code for cheap. This should be cheap, is what they're saying, if you didn't understand the translation. And usually when they say this is going to be simple, that's their way of protecting, because it's anything but simple. So just know the jargon out there and know the implications, guys. All right, let's look at 5-1. Let's go through these next 3 problems and we'll call it a day. But they're not short, so just brace yourself. 5-1. Josie prepares state and federal income tax returns for a variety of small business clients and individuals. She has no formal training, is not an enrolled agent, licensed return preparer under state law, CPA, accountant, or lawyer. Right? Basically, Peter, she's hanging out her shingle, right? Assume that there is no state statute either authorizing her to prepare returns or barring her from preparing returns. From time to time, when a difficult question arises, such as whether an individual can deduct a hobby loss, right? We're back to hobby losses under Code Section 183, for the expense of maintaining a home office. She does research at a local law school library, okay? So, off she goes. Is she engaged in the unauthorized practice of law? And again, I recognize most of you, if not all of you, have not had a chance to read this material yet, but there is no football this weekend, or professional football, right? By the way, aside from Maroon 5, who's playing at the Super Bowl, guys?
Travis Scott.
I Google it, but I don't have my.
Travis Scott.
Who?
Travis Scott.
What does he sing?
The rapper.
Oh, yeah.
It was someone
Hip hop.
from Motown.
My son listens to it.
Right, you looking it up?
Yeah.
One person I know it's not going to be, but I'm going to get his name wrong. What's the guy who's all the controversy? Riley? Kelly? Who's the guy? who
R.
rap-
Kelly.
R. Kelly.
No, it will not be R. Kelly.
R. Kelly's been surrounded with controversy for years.
All right, well, he just got deep.
After that show, Lifetime, I'm gonna see that. It's scary.
Looks like Travis Scott.
Travis Scott, there you go. What does Travis Scott sing? Do we know? I would know that through my wife.
I know Atlanta has like a big rap
Rihanna?
scene. No, like in Atlanta, where the Super Bowl is, there's a big rap scene. So,
Travis Scott's a rapper.
yeah, and then some guy's a big boy, so I guess.
Dating
they're-
Kylie Jenner.
I guess that they're from Atlanta, maybe.
Yeah.
Okay.
I don't know.
Yeah, Travis Scott is qualified to perform the
If
Super
you
Bowl.
listen to it, I
He's
guess
dating
it's
Jenner.
seen it.
That's amazing.
Definitely not country.
No, definitely not.
Very far removed.
Okay.
You're not gonna enjoy it.
No, it doesn't sound like that. Although I have to tell you, I'm afraid to admit this, but I'm not that afraid. Someone introduced me last weekend, and I have to say, I got hooked as soon as so I'm a little afraid to admit this. Is it called Lil Dicky? Do you know it? His lyrics are very creative. Have
It's
you
a
heard his
very
songs?
alternative style, yes.
Anyone else? Am I the
Little
only guy?
Dicky?
You've heard his stuff, right?
Who is Little Dicky?
I don't know.
He's a Jewish rapper, that's his.
Yeah, but he's very creative.
Jewish rapper.
Yes.
He must be the first ever.
That's
no,
literally his
he's
whole-
not, because you all know who's a rapper who's just coincidentally Jewish.
Oh.
guys were supposed to fill in the blank, but who's the guy who, name one or two rappers and he's it?
What?
Metro Boomin.
No. Who does,
Drake.
Drake?
Okay.
Drake's Jewish?
Yeah,
Drake's Jewish.
Yeah.
No.
yes,
Ah.
okay, just so you know.
Wow.
His mother is, from, Eastern Europe.
Wow.
So, who knew, right? See what you get on a Saturday morning? All right, so getting back to Josie. Andrew, what do you think? Unauthorized practice of law or not? And Trevor, see if you agree. Yeah. Yes, Trevor, agree or disagree?
I disagree.
John, who's right?
I didn't hear either one of their answers, but I don't think it's beyond, I don't think it is.
You don't think it is? Anyone?
I don't think it is either.
I don't think it is either, yeah.
Yeah, I mean, you know what?
Because you-
Notwithstanding that we looked at the case,
Based upon everything we were
in 2019, no one's gonna bring a case against Josie, okay? So, this seems like legitimate, little tax research, the state bar is not gonna come after Josie with guns blaring.
Because of loving and.
Yeah.
Question B, 5-1B. Same as A, except Josie's is an enrolled agent, entitled to represent taxpayers before the IRS complements the circular 230. B,
Even
Kevin,
then-
okay?
Yeah. She can still,
I think it would apply the same.
Yeah, Peter, you're agreeing up here, right? Okay, I mean, assuming there's no problem with A,
The difference is that she's subject to any possible penalty.
what do you mean by
Anything
subject to
wrong.
possible penalties?
No.
Because,
Because she's an enrolled agent and she's signed, you know.
well, anyone is subject to the penalties under what code section?
62.
6694. In other words, you prepare a return, even if you're not an enrolled agent and it's flawed, you have problems under 6694, right? 6694 applies universally to any tax return preparer,
Yeah, but
agree?
the way I read the problem is that Joe's prepared it based on, you know, I don't think it doesn't seem like she's registered, I think she's done.
Well, I hope she's signing the returns. If you get paid for a return, you should be signing it.
She doesn't know that, she's not.
Well,
Tax professional.
even those people who are not tax professionals know they better sign the return if they put a shingle out and just say, we prepare tax returns in our basement. Right? Otherwise, they have a problem under 6695, failure to sign a return. All right, so the answer is A and B, not a problem. Question C, same as B, except that client's return is under audit by state tax authorities, and Josie is preparing a memorandum to state tax authorities on behalf of her client. Gus, Mike, what do you think? Good, bad, thumbs up or down?
I think that she might be able to help, but she should recommend to actually go see an attorney.
this is all.
So you do think this is might unauthorized practice of law or not?
She's a enrolled agent, that's only for the federal, not for the state, so.
So
Yeah.
what's your response?
uh,
Eva, you were gonna say
I
it.
think it is UPL.
You think it's UPL?
Yeah,
Mike?
yeah, it should be.
I mean, sometimes at this point, when you're preparing memorandum, that has an aroma more of a legal document, right? So she's getting close to the edge, okay, close to the edge. So this could be a problem.
And why is she getting close to the edge? Because
Well,
of the
that-
state?
Well, not because it could be federal, but now you're presenting a memorandum of law, right?
She's not a lawyer.
And that could be a problem. Now, will the state come after her? I don't know.
Okay.
I mean, let's put it this way, and I don't know if the problem gets this far. Certainly if she shows up in court and acts as an advocate, then there's certainly everyone agree in this room, that would be the unauthorized practice of law, right? So remember guys, in ethics courses, you don't always have black and white. Here she's certainly gravitating towards the gray area, right?
Dark gray.
Question D, same as A, except Josie's a public accountant, but not a CPA. So, and the author's point, I think, in problem D is that whether you're a public accountant, meaning, I guess you've taken certain courses, you're not directly under Circular 230, right? So, does that mean that you have more of a risk of the unauthorized practice of law? Probably not, right? Viva saying you're not. So from your answer, this should be okay as well, right? Doing simple research is not going to be a problem. Question E, same facts as A, except now Josie's a CPA, thereby authorized under Circular 230 to represent taxpayers before the IRS. So would this be considered unauthorized practice of law? No. I mean, here, right, guys, we have certainly Circular 230 anticipates, right? Actually anticipates that people like Josie will do research, right? Question F. Same facts as A through E, except the clients often call Josie before buying or selling investments or other homes to ask what kind of federal and state tax consequences the federal and state tax consequences will be. Josie keeps a few resources in her own office and tries to answer these questions to the best of her ability. Now, any thoughts here? I mean, at some point, if she starts looking like a law firm, you know, the state is going to not look too fondly about that, right? If she starts looking like she's the go-to on rendering legal opinions. So, you know, doing some periodic legal research, and if you're an accountant, it's not a problem. But if she's just, to use Peter's description, a notary public who doesn't regularly do this kind of stuff, but tries to get people to use her services and charges egregious fees and holds herself out maybe as a colorable as a lawyer, but not saying so. At some point, she runs the risk of the unauthorized practice of law. Okay, so not to make your notes confusing, now that we're at Saturday afternoon and no longer Saturday morning, but we'd have to know how egregious was her behavior here, right? So again, I'm not trying to be equivocal, I'm not trying to make your notes, and sorry to say this, Kevin, dark gray, but you know, there are, here the answer is not entirely clear. Question 5-2. Ernesto works for Quadruple A Life Insurance Company as an agent. Ernesto's income is principally derived from commissions generated by the sale of life insurance, annuities, and related products. In assisting his insureds, he has found it useful to become educated in financial planning for higher education, retirement alternatives, and succession planning for family businesses. He often provides guidance for the insureds on matters, sometimes with spreadsheets and written memos about the tax consequences of various scenarios. While he strongly counsels his clients to consult with their lawyers on such matters, he knows that many of them do not, as he engaged in the unauthorized practice of law. So, Andrew, this has your name on it, right? Because your firm probably has, I don't know, has this kind of stuff, right? Mm-hmm. And how do you, without, I don't want to be too prying, but maybe I do. What do you do here, Andrew, and how does your firm handle it?
Well, I mean, he's not really implementing anything. He's not implementing any sort of succession. If he's acting in sort of a, just a, you know, he's advising, but I mean, he's not going to be able to implement any sort of succession plan or anything that will involve.
But he does render advice. He often provides guidance to the insureds on these matters with spreadsheets and written memorandum. Again, without prying too deeply, does your firm do this? How does your firm, with its clientele?
Sure. I mean, we don't
prepare tax returns, we don't draft documents at our firm.
What is your firm, just so everyone knows?
We're a bank, we're a private bank, and
then your
an
clients who
investment
come in
manager.
who ask about annuities and retirement plans.
Right, we don't have our own products or anything like that, but.
Right, but do you have in-house counsel who counsels people on this or not? Or do you just say, see outside counsel?
No, we counsel.
You counsel, okay. So just like this. Yeah. Is that a problem? And I'll add, I'm sure you think, no, but why?
Well, again, because we're not putting documents in place for the advice we're giving. If we're giving you advice to go see your attorney and implement the plan we've been talking
Do you put in writing that you should see your attorney before going forward?
There's disclaimers and things, of course.
Okay, when you say of course, that's good practice because you're not a.
Committees will describe, how we're acting, our services for them, so.
I mean, the point I'm raising is that there should be disclaimers, there should be written advice to make sure before proceeding to seek legal counsel. These are the kind of things that protect you, because in the absence of those kind of things, then you run the risk that clients were saying, hey, we were relying on your advice, we thought you were giving us legal advice.
Right, and most of the time we're communicating with the attorneys and CPAs.
Okay. That's fine, I just want to make sure.
No, I understand.
Okay.
It would be a big problem if there were no.
All right, so this answer could go either way. This answer, you're just doing this, and you tell them to consult with lawyers, but you don't have that in writing, that could be problematic. You could be deemed to be engaged in the unauthorized practice of law.
You should have one in writing, the fact that you are
So he could be?
telling them to seek.
Yeah, that you're telling them to seek independent legal counsel before proceeding with whatever
So it's
planning
not-
advice you might render.
It's not UPL.
It's not, there's no UPL unless you fail to make the proper disclosures. Same facts as an A, except that Ernesto happens to be a CPA. But your answer differ if Ernesto did not routinely counsel his clients to consult attorneys. In any event, should that really matter? So, again, some of you may work for CPA firms, and as part of the CPA firms, you have the downstairs which renders financial advice, right? Or does financial planning. What would you recommend there to Ernesto, the CPA? I mean, I think you're on the same path as before, is that Ernesto is not a licensed attorney. Ernesto has the risk that if Ernesto, look, can talk about some of the legal consequences, but has to say prophylactically, I'm not an attorney. You should seek legal counsel to ensure that what is being done here is correct. That there are people who are trained. I'm trained to give advice. I'm not trained to use your words, implement that advice. Which is fine. I mean, we live in worlds where some people bring the client in, educate them, and then there's someone else who brings them across the finish line.
You can certainly play a big role in implementing.
Absolutely. Absolutely. Kevin, were you going to say something?
No, I was just scratching my head.
Okay. Problem 5-3. Penny, CPA, represented a taxpayer before the IRS in connection with a dispute on taxpayer's accounting method. Penny researched accounting methods in the county law library but did not cite any cases in her communication with the IRS. Did Penny engage in the practice of law? And it said, see this 1960 case, distinguishing the case that we just read, just to remind people, because maybe the AGRAN is the case we just looked at, okay? On the grounds that Zellman can, however you pronounce it, neither read the law nor cited any cases, although he performed research into law libraries. So there, the accountant prevailed, but does that seem logical? The accountant prevailed, if you don't mind me saying, because the accountant did a superficial job. You understand how this case held? Remember in the case that we just looked at, the accountant lost, right? And the accountant lost because the accountant did a really good job, right? Because did good legal research. Here, the accountant in the 1960 case that follows prevails. Why does the accountant prevail? Because he neither read the law nor cited any cases. So that accountant did a superficial job, and he wins? Now, on the face of it, that seemed absolutely crazy, right? That you could prevail, and that's why this is just silly. And what I mean by silly, the law was silly 50 years ago, where accountants could win if they claim they did a superficial job. Now, in the year 2019, in my opinion, you would never, as a practitioner, open yourself up and say, look, I didn't read too hard, I didn't cite cases, I should command my fee, because then you may, emphasis on the word may, open yourself up to a malpractice suit, because you're essentially declaring to the world, I'm not very good at what I do, maybe I luckily won that one, but do you see, it's just silly. All right, so the authors have this case here just to illustrate what the law looked like, and I think that's a good way to differentiate where we are in the year 2019. Let me give me 5-6 more minutes just to make your job easier for Wednesday, okay? So Wednesday, if things fall into place, we do have our guest speaker, but I'm not sure if we'll finish in the entirety. Let's talk about what Chapter 5 has in store. Beginning on page 245, we talk about the federal doctrine of preemption. And that's spelled out in on page 245, the Sperry case, Sperry v. Florida, about a lawyer who's practicing in Florida, but who is not licensed to practice in Florida, and whether or not he prevails. Then we have a whole series of cases. Beginning on page 250, there's the discussion of multi-jurisdictional practice. Now, you might say, who cares, because you're an accountant, you can practice in any state, lawyers have restrictions, but you should, because if you're tied with a lawyer who's practicing in the wrong state and you're with that lawyer, you may never collect your fee, all right? Because again, when lawyers get sued or there's a problem, typically the accountant is going with the lawyer. So there's a very interesting case on page 251, Burbrower, that discusses when a lawyer who's licensed in New York tries to practice in California. Big problem, okay? So big problem, client does not want to pay fee. You can read that case, you will see the outcome, right? I will encourage you, if you could, on page 264, I will probably redraw this, but people who've had me in other classes know I'm a big fan of stick diagrams, okay? Stick diagrams are great for you, they're great for the client, because sometimes things are hard to understand, right? And one little picture can really clarify here. And here, there's a law firm, Elrod, that is rendering services to Mother, okay? They're rendering services to Evelyn Condon, DC, Evelyn Condon. She dies. Poor Evelyn, she dies. Evelyn has 2 children. Michael and Carolyn. Michael and Carolyn. I have CMM, Carolyn. Do they love each other? Hate each other, right? They hate each other. And they bring suit against each other, okay? And Michael is from Colorado. And she's from California. I should put this in parentheses. California. He's from Colorado. And he's going to use the firm his mother used. He's going to use Elrod. That's the name of the firm. He's going to retain Elrod, his firm. She's going to retain another firm called CARR, C-A-R-R. And there's going to be a question about fees, okay? So read this case, it's interesting. And we'll talk about this picture for next class. And then, if you look at page 273, we're going to talk about advertising. And what are the parameters of what you can advertise? Right, so there's some very interesting cases here. I'll call it some surprising outcomes. I don't know how, assuming our guest speaker arrives, I don't know how long he'll speak. Not as long as Bob Stern did, that's for sure. So do, if you can, try to finish up chapter 5, okay? Have a great weekend, guys, and we'll see you on Wednesday.